Last name.
Matthews.
First
Okay.
name.
Matthews.
Hey, Deputy,
Yes, sir.
regarding Miss Jackson, have her do a waiver, please.
Got you. She had a medical problem. That's why I was moving back and forth.
Understand. Have her do a waiver. Thank you very much.
We're gonna use for that.
Miss Matthews, good morning. All righty, Miss Matthews, it's alleged you committed the offense of criminal trespass. The bond in that offense is $1,500. Will you be able to make bond, Miss Jackson?
No, I'm waiting.
Miss Matthews.
After this, I have to wait on the Cal County to come get me for a family violence order. So whatever.
All right. Not a problem. I understand everything you're saying. Got it. All righty. So your next court date, ma'am, is going to be November the 11th. Correction, November the 7th at 8:30 a.m. Now, let me check one thing.
Said November the 7th, I come back, sir.
Correct. You did not put whether you're employed or not. Are you employed?
Yes, I work for MARTA. That's why I'm trying to get up out of here.
All right. About how much do you make per month?
Yeah.
I'm
I'm sorry, sir. I didn't even know I called you professional. I just did 12 years in prison, sir.
That's all right, ma'am. That's all right. All I need to know is about how much do you make per month?
I don't count about money, sir. I make like a band a week, so I'm not sure.
All right. Thank you very much. All right. Thank you very much, ma'am. I'm going to appoint counsel to assist you.
Okay.
All righty. And your next court date is the 7th. Thank you much.
Thank you. You said 1,500, sir.
Yes, ma'am.
Okay, thank you, sir. You have a nice.
Yes, ma'am.
Charges. No. Yeah. Penalties. Session. My name is Elaine Washington, and I'm the judge that will be presiding. The court will call the case of the state of Michigan versus Lolita Jones, case number 23S00437.
Good morning, Your Honor. AP Rachel McDuffie on behalf of the people.
And good morning, Your Honor. Regina Garrett-Caraher on behalf of Miss Jones. Miss Jones, can you turn your camera on and state your name for the court? Oops. Oops, anyone?
Miss Lolita Jones. Miss Lolita Jones.
Yes, Your Honor.
Are you sick?
Yes.
Yeah, she's got a pretty bad sinus infection, Your Honor. I apologize.
Thank you, please.
I don't know. Can you guys hear me?
Yes. Can you please state your name?
Lolita Jones.
Thank you.
And Your Honor, today is a date and time set for a pretrial in this matter. I've spoken with Miss McDuffie, and I do recognize that there's a bond violation report that we need to address, which I will address at whenever Your Honor's pleasure. But I would also be asking for an adjournment in this case. I intend to get an investigator involved and do a few interviews of some witnesses that were there. And we just need some time to get that to happen.
So let me arraign her on the bond violation. The community corrections bond violation indicates that you tested positive for opiates. And does she have permission to use THC?
She does have a valid medical marijuana card, Your Honor, and she states to me that she's been taking a lot of medication for colds and whatnot, and she realizes that that's probably not where the opiates came in. She believes that it may have been some bad marijuana that she got that was laced, but she states that she does not take any other illegal substances, and she does have a valid medical marijuana card.
All right. Before we get to that, ma'am, you're entitled to have a hearing regarding this matter, at which time, if it is found that you violated the terms of your bond, you could have your bond revoked. Do you understand that?
Yes, Your Honor.
All right. As to the bond violation, what does your client want to do?
Well, Your Honor, she would admit to missing the tests. Miss Jones is the single provider of financial support to both her and her children.
I'm not violating her for the missed test. I'm violating her
Okay.
for the opiates, which is what I just arraigned her on.
Okay, all right, because I was going to say that's why she's missed the test. But as far as the opiates are concerned, She would admit to the violation, and she believes that the only way that she would have gotten that is through some bad marijuana. So she understands that she
We need to
can't
deal
do
with
that.
whether like she's gonna admit or not. So you can do the explanation afterwards, but it's a step-by-step procedure. If she wants to admit to it, then that's what we'll do.
Yes.
All right, ma'am, please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, Your Honor.
Thank you. Ma'am, is it true that you tested positive for opiates?
Yes, ma'am.
I find that there's a knowing, willing admission to the violation of the bond. Are you satisfied, Ms. McDuffie?
People are satisfied, Your Honor.
Thank you. All right, now Ms. Garrett Carhart as to her explanation.
And again, Your Honor, her explanation is she's not sure how she got the opiates in her system. She believes that it may have been through some of the marijuana that she did ingest, which she does have the medical marijuana card for. She understands that that's not really an excuse, but it is a reason. And she notes that she will, from now on, make sure that that does not occur. And I would also like to add that the allegations against her did not involve drugs in any way, and she does not have a significant history of any type of other substance abuse or use issues.
Ms.
Your Honor,
McDuffie?
Yes, Your Honor. So yes, the allegations in this report deal with a high level of intoxication that appears to be from alcohol. She's, I think, currently just on the PBTs. I guess that's sufficient. I usually prefer ETGs if possible, but I don't have any other knowledge. I can check really quick. Ms. Jones does have another warrant request into our office for a retail fraud case in another jurisdiction that has not yet been assigned for review. That's been actually hanging out for quite some time. But I don't see any allegations right away. I don't have that report handy. I'm just scanning, pardon me, really quickly through the history to see if there's anything else here. That's obvious. So I don't see anything else relating to drugs, just alcohol, to my knowledge.
And Your Honor, if I may, in the police report, it doesn't say they investigated. They intentionally did not investigate as an OWI. So I'm not sure that there was a high level of intoxication. The officer actually wrote that due to the level of intoxication and the ability to separate them, he was fine letting them go at the scene. So I'm not sure where the high part would come in as a level of intoxication, even at that point.
Thank you. All right, in this particular case, ma'am, you are in violation of your bond. I am going to continue the testing as was already ordered, with the exception that you should be ETG testing. I'm not certain why you're not. I'm not certain how Ms. McDuffie came to the conclusion that it was only PB. I guess that's all I see is PB. I'm going to order ETG testing.
And what is that testing, if I don't mind? You don't mind me asking?
That's for alcohol.
Yeah, I don't even drink. That was just the weekend of my birthday.
As I indicated, I'm ordering ETG testing.
Okay, no problem.
As to her marijuana card, I don't see where this court actually approved the marijuana. Community Corrections doesn't get to approve that. I'm the one who has to approve that. So I need to have that submitted to this court for approval.
Yes, Your Honor. Would you like just the card, or do you need me to submit it in a motion?
I need the letter of necessity, really. The card is not what determines it. The necessity for it that determines it.
Okay.
All right. In terms of the next court date, does November 16th work with your calendar, Ms. Garrett Carr?
I believe so, Your Honor. Let me check really quick.
Okay.
Sorry.
No worries.
November 16th would be fine.
All right, November 16th at 9:00 a.m. I presume there's no objection to the adjournment. Is that correct, Mrs. Duffy?
No objection.
And we would be appearing via Zoom again, Your Honor.
Yes, ma'am.
All right. Thank you so much. Thank you,
Got
Ms. Duffy.
Otherwise, you're welcome.
Have a great day, everyone. And you can log off, Ms. Jones.
Thank you.
That we had with the prosecution is fairly accurately represented in here. However, there is no mention that this is supposed to be a deferred sentence, and I'd like to have that added as that was the agreement.
All right, thank you. It does indicate prosecutors deferred in the file.
Other than that, we're ready to proceed, Your Honor.
Ms. McDuffie?
Thank you, Your Honor. Nothing much from the people. Again, another situation where I'm glad that it wasn't much worse. I believe that the child was, I think, 3 years old at the time. And I'm very grateful that he did not take it upon himself to attempt to cross that busy street and get back home. So I hope that things are much better, much safer, I think, now. And I wish everyone the best.
Thank you. All right, Ms. Kopek, is there anything to say?
I never mind. No, I don't have anything else to say.
Your Honor, Ms. Kopek has been taking this matter very seriously. She's already complied with the terms of CPS. She's attending classes as directed by CPS. She's created additional safety measures within the home right after the incident. She doesn't use alcohol or drugs because she's currently pregnant. Sometimes she has difficulty expressing what she would like to say. But she is taking this matter very seriously.
Thank you. I appreciate that information. I appreciate your understanding. Explaining why she was unable to speak just a moment ago, because I obviously wanted to know what she started to say. Follow the recommendation with the exception of adding the deferred. I'm going to add that was a part of the agreement. Ma'am, it's the sentence of this court that you serve 365 days in the Washington County Jail, 0 days credit. 365 are suspended. So if you do everything you're supposed to do, then you don't have to do any additional jail time or any jail time on this particular case. Fines and court costs for a total of $425 and $30 per month in probation oversight fees. You must meet with probation when and where directed, including any and all home visits, and comply with the terms of your CPS, which I understand you've already done. I think you've already done the parenting classes, so that shouldn't be any added burden to you. You to provide proof of any appropriate child safety measures to the probation department. No assault or threatening behavior towards anyone. Submit to, pay, and be responsible for random drug and alcohol tests. No use or possession of alcohol, marijuana, illegal drugs, or drug paraphernalia, and no being in the presence of anyone using those or having any firearm components, ammunition, or other dangerous weapons. I'm going to do a review in this particular case, and I'm going to do it in 90 days. They'll put us on January 11th, 2023. I'm sorry, 24.
How much am I gonna owe a month, Your Honor?
Probation will go over that with you, ma'am. I gave out the number earlier. Did you write that one down?
Yeah.
Okay. You call them tomorrow. They'll go over your contract with you and let you know how to divide that up into monthly payments. I'll also tell you that if you complete everything within the first 90 days, because you're on, you're on 18 months. If you complete everything within the first 9 months, then you can be eligible for early discharge from probation. Okay, so if you get everything done in that time frame, then you can get an early discharge, and this won't be on your record. Okay.
All right. Thank you, Your Honor.
Please contact probation tomorrow after 9 o'clock, ma'am. Okay.
Thank you, Your Honor. Thank you, Ms. McDuffie. Have a good day, everyone.
Have a good day.
Morrow in 17-28387. and 28388. This is all, of course, this we're intimately familiar here. This is all about money.
Yes.
And where are we on?
So she was court ordered to pay
No, no.
400. She fell behind since April, but last month she made a payment of 3,200.
Okay.
Which brings her current for the rest of the year. Just so you know.
The other side of the coin is what's the balance of it?
It started at 199.
I know.
It's at 185.
Sir,
185.
185,000. Okay, so it started at what did you say?
199.
Yeah, so 15, let's just say 15,000. And she's been on probation here since 5 years.
Yes, sir.
So it's 1,000 a year is all. What we're talking about here. So we don't need a computer to tell us that it would take 185 more years for you to complete this at this rate. Is that what your master plan is? Of course. The victim is not happy about this. I can't speak to her, but she attempted to at a function. And the fact that she happens to be your mother is even a worse, adds a chapter of bizarre to the whole scenario. But that's, I personally don't feel as that a mother and a daughter should be estranged like this. But it's your fault, the way I look at it, not hers. And the betrayal of trust is compounded by the fact that you can only pay about $100 a month for this almost $200,000 loss. My guess is, knowing that lady, that she would forgive some of this portion of it, maybe a large portion, if you showed a little more effort. So how about paying more per month? What's the status on that? Where are we on that?
Your Honor, how many jobs have you been holding?
At least 3, sometimes 4.
You got it?
She said multiple.
Okay, 3 jobs, but it's still 1,000 a year. It's $100. She's got 3 jobs, and all she can come up with restitution on this is $100 a month at 3 jobs. You got to do better than that. You got to figure it out. I'm not going to go out and get the job for you, but
Yeah, we are
just
there. Just so you know, I mean, we received assistance on the money that was paid last week, and I talked to those people, and there is a plan right now that we're working on to try to accomplish exactly what the court is at.
okay, because if I don't see a plan that is developed and put into action soon, we're going to pick up on a motion to revoke probation. Okay. You've had 5 years, man, to get a plan underway and start working on the plan and getting it accomplished. 5 years later, I see little or nothing. And like Mr. Smith said, there's a third party now that's involved that's paying your indebtedness or fronting your indebtedness. It's one way or the other is going to have to happen. And the court's going to push and forward. But we're talking about 10 years in prison. And the restitution would not disappear. It would still be part of the judgment. Because I guess the parole people to work with you on, but the court is losing its this is a very bizarre set of facts. And I've been patient. But it's 60 months have gone by and there's really not material progress being made here in getting that lady taken care of. And which is the way you fix a loss of money like this. You got to pay him back. He's owed that. And I'm going to review this in 3 months, 90 days.
Yes, sir.
And on the record, if there's not material change in progress on this, then all things being the same, I'm going to ask the probation office to move forward here on a administrative matter that is the first step toward a motion to revoke probation, and then we'll take care of it in a different way. But then you're on probation in 3 cases.
It's
So you got to figure it out. Like everybody else has to figure out their indebtedness, and failure is not an option really here. Failure of this gets you in prison. We'll see everything. See what happens in 90 days. Please get a resetting.
Yes, sir.
On Kieran McAndrew.
Thank you so much. Appreciate it. Thank you.
All right. We have a first amended motion to revoke unadjudicated probation that is, I guess, is that what we're doing? The motion to revoke?
No, this is a bond hearing.
Oh, okay. When are we going to do this hearing on the motion to revoke probation? That's what I want to get to. Who's the probation officer? There you go. Mike was completely covered up.
It's my big head, dude. I apologize.
When can we have this hearing? Which is what we need to do.
We're still in the discovery process on the new case, the aggravated robbery, because there's a phone dump that we're trying to find out if it exists. I've got one of the phone dumps, but I'm trying to find the other one. So
well, we never took care of that original that was filed a year ago. There's no hearing was ever held on that.
correct.
That's correct, Your Honor.
All right. Well, I want a hearing on something.
Yes, sir. I think we can be prepared at the next setting. Just for this particular setting, we're requesting a bond.
Yeah. What's his bond right now?
He has no bond on the probation, and the bond for the aggravated robbery is $500,000.
All right.
And I do have
So So we have a second-degree felony he's on probation for in 2016. Then we have this new indictment on aggravated robbery, which is a first-degree felony. And then this first amended motion alleges 8 violations, 7 from the original motion, and then the new crime. What I want is a hearing on this. When can we get a hearing on this motion? I don't like the whole idea of putting him out on bond now.
Do 3 or 4
It's a
weeks.
second serious felony that he's had to have over his head now on my watch. One of them is on my watch now. And this motion, the first motion, like I said, was a year ago, and we kind of stalled on that one. We need to catch up, if only to handle the allegations in the first one.
Yes, Your Honor, and if I may, I do have his mentor here, Mr. Broussard, that has been assisting me. As Mr. Laird stated, we are still kind of in the discovery phase with that aggravated robbery. There are some issues that I have discussed with Mr. Laird. And so that was the reason, one of the reasons why we were requesting a bond reduction as well as a bond.
Okay, let's see. See, there are 8 allegations in this first amended motion to revoke probation. 5 of them are crimes. No, we're not going to. If we have to have a bond, it'll be $1 million. But let me finish. You've got to work with your attorney on trying to explain away this stuff, because any one of those is enough to put you in prison for 20 years on the burglary. But 5 allegations of crimes while on probation, 1 violation is all it takes to get revoked. 5 crimes, a crime is the most serious of the violations. You got 5 of them out of 8. That's 60% of the allegations of wrongdoing are criminal.
Sir.
But it's not a debate. We'll have a hearing under the rules of evidence where the state gets a chance to present, y'all have a fair chance to present, and then you don't have a jury trial with me on a motion to revoke probation. Then I make my decision. But it's language too long. I want a hearing within 4 weeks.
Yes, sir.
Everybody be ready?
We'll talk. Yes, sir.
Mr. Stevens, can I speak real quick?
Well, you need to talk to her before you say something. Before you say something. And the others, urine samples for synthetic marijuana, which is hallucinogenic in the worst sort. Here we are, the curfew violation. There's tetrahydrocannabinol again in August. It doesn't say how you possess that. Committed
No.
MDMB, okay. Unlawfully carrying a weapon, August 21st. And then not the least of which, of course, is this July 26th mess.
And Your Honor, obviously with those allegations, if the court would consider not only obviously drug patches, but a GPS monitor.
Yeah, I'm reading the probable cause affidavit on the indictment, and that's very disturbing. You got all that. Oh, let's have a hearing on this in 4 weeks. All right. And 3 weeks if.
Yes, sir.
Y'all want
She and I'll be
something.
talking, we'll talk, we'll try to get it all shored up before we get there. We'll have a plan.
Oh, Yeah, I want this before Thanksgiving time.
Yes, sir.
Oh, yes.
Okay, thank you. So.